Oh,
Good afternoon, everyone, and thanks for coming today. Uh, I'm George Mocsary. I'm a professor of law at the University of Wyoming College of Law. I'm
each other.
also the director of our Firearms Research Center. I'll
Don't,
just
don't worry.
start by asking that everyone mute him or herself.
I think
There we
everybody's
go.
on mute. This thing.
I'm looking for the mute button. I can't find it on my end, so I would just ask that you mute yourself if you don't mind. Um, We're to give you some background on this presentation. I first gave this presentation about 3 years ago now. Um, uh, Maybe it was about two or 3 years ago now, at an event that we did on conservation law at the Firearms Research Center. It garnered a lot of interest, and lots of emails came in about people asking if it'll be offered again. Then the Jackrabbit Bar was in town, and they asked if we would do it again, and we did. And then we got even more requests to do it again. And so here we are doing it again. Last Saturday was Conservation Day or Hunting and Conservation Day or something along those lines. And so we thought that in honor of that, we would open it to the public, do it online, and let everyone attend. Um, I'll say that this will be a little bit different from the ordinary CLE. So we're not going to go through, how to write a lease or how to do an LLC operating agreement, or what are the steps required to do a closing for a real estate transaction, in New York or Colorado or any given state. It'll be a bit more higher level. It will touch on the Second Amendment. Someone mentioned it as we were waiting for everyone to join, but it'll be a lot broader than that. And it'll focus on the states in our region, so Wyoming, Colorado, Nevada, Montana, the Dakotas, and so on. But it'll start all the way back in medieval England. So to give you a roadmap of what we're going to do today, um, uh, we're going to talk about history with respect to the Second Amendment, because New York State Rifle and Pistol Association said that history is what determines the scope of the Second Amendment right. Then we'll talk about game laws in England, or well, I guess we'll start with game laws in England as antecedents of federal and state rights to hunt. Then we'll talk about the new United States and the right to hunt, the 20th century United States, and then state constitutional rights to hunt. Um, and just so everyone knows how things look on my screen here, I've got the audience here on my right side, my notes in the middle, and the PowerPoint slide that we'll be using on the left. Can everyone see the PowerPoint slide? Is that shared properly? Great, super. Okay, so let's get started. So English pre and post-colonial game laws made hunting a monopoly of the crown and those privileged by the crown. They sometimes imposed draconian penalties for their violation, including the death penalty. All that started with William the Conqueror, who declared that besides owning all of the land in England or in the United Kingdom, well, I suppose in England, he also owned the wildlife. Um, uh, Before that, in accord with Roman law, Anglo-Saxon England had considered wild animals to be ferae naturae, or belonging to no one, and anyone could hunt them. Now, after William the Conqueror or William the First, no one could hunt, not even on one's own farm, for example, unless authorized to do so by the king. As we'll see later, in America, where anyone could hunt, the hunting restrictions in Great Britain were often denounced as affronts to liberty. Um, so let's canvass some of the infamous game laws passed under this asserted monarchical power. You'll notice that the more tyrannical the monarch and the less need for national military readiness, the more severe the laws and their enforcement. Um, Game laws aimed at commoners, and their ulterior motives were long-standing. Following the 1381 Peasants' Revolt, a 1389 statute aimed to prevent seditious gatherings, in part by preventing commoners from assembling armed for hunting. Um, the minimum income requirement for hunting was fairly low. It was about £2 per year. That's about $2,800 today. And that was the same minimum income for voting. Persons not allowed to hunt also couldn't have hunting dogs or nets. Henry VII, the first Tudor monarch, observed that the proliferation of crossbows was leading people to neglect longbow practice and to shoot, quote, the king's deer. By the king's deer, of course, he meant all deer in England, as we discussed. So in 1503 or 1504, he banned crossbow use, with exceptions for home defense and those with annual income from land of at least 200 marks. That's about 112,000 pounds or about $140,000 today. So many law professors wouldn't be able to hunt, at least with crossbows, under that rule. Under Henry VIII, a 1514 statute eliminated the home possession exemption for crossbows, and brought handguns, both of which the middle and lower classes were using to hunt, with the annual income level raised to 200 pounds or about $217,000, $220,000 per year income today. Henry VIII also authorized search and seizure from anyone's home suspected of having a handgun or crossbow. And just as an aside, this is one of the origins of the Fourth Amendment today. Not our focus, but all wrapped up in this, right? Wars with France forced Henry VIII to lower the property qualification for handguns and crossbows to 100 pounds. We'll come back to the military angle, but that's an ongoing theme here. The system under Henry VIII changed regularly. So, for example, income restrictions on crossbows and handguns were extended to hackbutts and to demi-hacks. Both are types of shotguns. A demi-hack is basically a short-barreled shotgun. Sometimes there were license requirements, but those in market towns or boroughs with a house more than 2 furlongs or 440 yards outside of town, or living within 5 miles of the coasts or within 12 miles of the Scottish border, or on various small islands, could possess guns. They can use them for self-defense or target shooting, but not for hunting. In 1544, facing a two-front war against France and Scotland, Henry VIII issued a proclamation authorizing all native-born subjects to use handguns and hagbuses, another type of firearm, regardless, quote, of any statute heretofore to the contrary, end quote. After the war's end, the 1546 proclamation put back the previous restrictions. And you'll notice that this is a pattern that goes on. Edward VI and Philip and Mary enacted various restrictions that corresponded neatly with their persecutions of Catholics and Protestants, respectively. Elizabeth I, she was the last Tudor. She was at first much less repressive. She was actually also an avid huntress, preferring the crossbow. She wasn't very concerned about enforcement of the game laws, but she became more repressive after a Catholic plot to assassinate her, when she also enacted more severe arms control laws. Nevertheless, at the end of her reign, foreign visitors were surprised to see that peasants were allowed to use dogs to hunt England's plentiful game. The local sheriffs and justices of the peace apparently didn't put much emphasis on enforcing the Tudor arms control laws. So, for example, in 1550, a Norfolk clerk reported that on any given day, there'd be 60 people hunting, none of them meeting the property requirement. Okay, but it was the Stuarts who would impose new game laws and restrictions, upend the English militia, and pursue the most aggressive arms control program in English history. Their extremes were among the founders' main impetuses behind the Second and Fourth Amendments. James I also loved to hunt. Unlike Elizabeth, he was jealous of others hunting. He cracked down on commoner hunting and, importantly, on their, quote, having or keeping as the using dogs, guns, and crossbows. He added a royal penalty to the legal one, and he asserted that even nobles couldn't hunt without his permission. Among the people who annoyed the king by ignoring the anti-hunting proclamation was actually Sir Edward Coke. I see some notes here that the slides aren't advancing. They're not supposed to yet. Don't worry. Was Sir Edward Coke. He was formerly the Attorney General and at the time the Chief Justice of the Court of Common Pleas. Coke would become a leading opponent of the Stuarts' despotism. He also imposed first James I here a £10 annual income requirement for hunting, and then £30 depending on the type of game or method. Note that the earlier income requirements were based on the Crown's hunting monopoly, but targeted at specific weapons. These targeted hunting directly. Warrantless search and arrest was authorized for people who hunted illegally and for people who possessed greyhounds or so-called setting dogs, but who didn't meet the £10 income requirement for hunting. James I and his son Charles I worked to disarm their enemies, which often included practically everyone, and for good reason. They were quite despotic and quite tyrannical. The British Civil War. Charles I started the British Civil Wars. He gets executed for trying to overthrow Parliament. Then there's the interregnum between the two wars. James I is also executed. Under Charles I, the restored Stuart, it was looking like there was going to be another English Civil War. So basically the military puts in Charles II, the restored Stuart, and under him, Parliament initiated the strictest arms control program England had ever known. The 1671 Game Act forbade the vast majority of the population from hunting, and it barred non-hunters from owning guns or bows. It raised the income qualifications for hunting, not just for possessing certain hunting arms, from £10 to £100. And it authorized more searches and seizures. Again, think Fourth Amendment here. In 1686, his son, James II, shortly after the acquittal of one of his fierce political enemies for carrying a gun in church, something that was completely legal, ordered full enforcement of the Game Act of 1671. So in sum here, Charles II and James II radically attacked the long-established order by attempting to disarm completely almost everyone under the pretext of the game laws. For centuries before, the Crown had mandated ownership of types of bows and other arms and worked to ensure that Englishmen would be expert in their use. Both of them, because of their brutality, had every reason to fear an armed population. And so all this led to the Glorious Revolution, or the Bloodless Revolution, in which James II was deposed, and the 1689 Bill of Rights. And so, the 1689 Bill of Rights contained a provision that, quote, "The subjects which are Protestants may have arms for their defense suitable to their conditions and as allowed by law." But because the 1689 right was for their defense and was subject to one's condition or degree, it allowed for continuation of game laws that prohibited commoners from hunting. Okay, so why does all this matter? Why does this history matter? And remember, this is history with which the founders were intimately familiar. This was part of their background, right? And part of the background of the colonists as well. Why does this matter? Well, because as suggested, hunting rights aren't just about hunting. First, hunting was often seen as complementing and sharpening the soldier's skills. An Englishman during Elizabeth I's reign observed, quote, "Hunting is a military exercise, and like stratagems are often invented and executed in war against soldiers, as the hunter doth against diverse kinds of beasts." As mentioned, it was the norm for monarchs to keep their people armed so that they could be good soldiers. For example, in 1365, Edward III ordered archery practice with bows or crossbows on church feast days, and forbade other sports like handball or football. But as the Stuarts knew, these same skills could be used to overthrow despots, right? And we'll see later, it was really the Stuarts' brutality that the founders were really concerned with. And the mention of the wicked Stuarts and things like this shows up in cases even into the 19th century relating to the right to arms. Anyway, second, in addition to sharpening the soldier skills, was food, sport, and more broadly, inclusion, right? The nobility could adapt to game laws in some ways, for example, by hunting birds in flight, right, with shotguns and such. But those who couldn't own hunting arms couldn't do that. Historian Robert Held said the following, quote, "It was one thing to forbid a man to load his family's dinner table by an easy means, and quite another to keep him from doing so." And in doing my research on this topic, I spoke with uh, uh, folks from Mississippi, from a very poor region of Mississippi, who said that hunting, even in this century, I suppose even in the second half, the latter part of the 20th century, hunting was the only way they can get lean, fresh, healthy meat on the table. So relatively recently. The 1671 Game Act, which we mentioned, helped the rural gentry assert its social superiority. Its overt purposes were to strengthen hunting rights of the nobility and stop hunting by commoners, and preventing future revolutions was a clear, unexpressed purpose. And that brings us to William Blackstone, the famous William Blackstone. He wrote that feudalism was founded on keeping subjects, quote, "in as low a condition as possible, and especially to prohibit them the use of arms. Nothing can do this more effectually than the prohibition of hunting and sporting." Tyrants used game laws, quoting Blackstone still, for prevention of popular insurrection and resistance to the government by disarming the bulk of the people, a reason oftener meant than avowed by the makers of the forest or game laws. So Blackstone, in detailing the common law protection of human rights, first set forth in his famous treatise, Commentaries on the Law of England, the three primary natural and absolute rights. So personal security, personal liberty, and private property. And he then listed, perhaps more famously, five what he called auxiliary rights. And those auxiliary rights are the ones that protect the primary rights. And the fifth auxiliary right was, quote, "having arms for their defense suitable to their condition and degree, and to such as are allowed by law. It is indeed a public allowance under due restrictions of the natural right of resistance and self-preservation, when the sanctions of society and laws are found insufficient to restrain the violence of oppression." In other words, as we move to the American experience, we should think of the right to hunt as a preservation of the right to citizenship and social inclusion. So let's move forward a little bit to the United States. So the right to hunt has deep roots in America. As Blackstone observed, British game laws were used to keep commoners from hunting and sometimes from having firearms at all. But here in America, English pamphleteer, William Cobbett wrote in the mid-1700s, quote, "As to game laws, there are none except those which appoint the times for killing. People go where they like, and as to wild animals, shoot what they like." End quote. Hunting was the, quote, "sport which is the most general favorite," end quote. Most of the immigrants from the British Isle who emigrated to America were not allowed to hunt in the old country, but here it was open to everyone. It wasn't long before the Americans started behaving with more independence than the monarchy liked or wished. The colony's final break from the crown came when King George III imposed an arms embargo on America and tried to carry out arms confiscations. In all theaters of war, Americans' experience with firearms, largely gained from hunting, helped make them effective fighter. And just one example of dozens, in 1789, historian David Ramsay recounted the 1775 Battle of Bunker Hill, and I'm just quoting here. "None of the provincials in this engagement were riflemen, but they were all good marksmen. The whole of their previous military knowledge had been derived from hunting and the ordinary amusements of sportsmen. The dexterity by which long habit they had acquired in hitting beasts, birds, and marks was fatally applied to the destruction of British soldiers. End point. Americans believed that they had the right to hunt, and they actually mocked the hunting restrictions in England. Just some examples here, starting with the colonies, the English game laws were never enforced in America, even when the Stuarts replaced colonial governments with their loyalists. The Virginia Colonial Charter granted Virginians the right to bring and import arms for their defense and otherwise, such as hunting. The Plymouth and Massachusetts Bay colonies had statutes that formalized what was already the common practice, quote, that fowling and fishing and hunting be free. After independence, Pennsylvania was the first state explicitly to protect hunting in its state constitution in 1776, quote, the inhabitants of this state shall have liberty to fowl and hunt in seasonable times on the lands they hold and on all other lands not enclosed. Thomas Jefferson, an avid hunter since the age of 10, proposed similar language that ultimately didn't make it into the Virginia Constitution. The reference to the use of arms on lands they hold and on all other lands not enclosed was an explicit response to the English game laws, under which, quote, the freeholders of moderate estates were deprived of a natural right. The body of the people kept from the use of guns are utterly ignorant of the arms of modern war, and the kingdom effectually disarmed. After Vermont declared independence from New York in January 1777, that's right. Another interesting aside here, Vermont declared its independence not from England, but from New York in 1777. It split off. It was an independent nation in somewhat of an ambiguous, state of existence for a little while there. But its constitution of that year of 1777, which is still in force, says that, quote, the inhabitants of this state shall have liberty to hunt and fowl in seasonable times on the lands they hold and on other lands not enclosed. When the new U.S. Constitution was proposed in 1787 without a Bill of Rights, the Anti-Federalists from Pennsylvania proposed the following amendments, quote, that the people have a right to bear arms for the defense of themselves and their own state or the United States for the purpose of killing game, excuse me, the inhabitants of the several states shall have liberty to fowl and hunt in seasonable times on the lands they hold, and on all other lands in the United States not enclosed, in like manner to fish in all navigable waters and other private property without being restrained therein by any laws to be passed by the legislature of the United States. So right to bear arms for the defense of their own state and the United States and for the purpose of killing game and liberty to fowl and hunt. The amendments were defeated because the Federalists convened the convention hastily before the Anti-Federalists could organize. So the Anti-Federalists published their famous Dissent of the Minority, which reiterated these demands for a Bill of Rights and was circulated nationwide. Interestingly, Virginia Federalist Alexander White said that these provisions, which he and others thought were, quote, clearly out of the power of Congress, end quote, were proposed, again quoting, to induce the ignorant to believe that Congress would have a power over such objects. There was discussion in some of the debates over the Bill of Rights. Someone said that the federal government has no power to enact criminal law, and we realize how silly that is today. This was another one of those things that some people thought Congress didn't have. Congress could just not regulate the power to hunt or the ability to hunt or the ability to bear arms. When our Bill of Rights was being discussed, James Madison and other Americans said that the English arms right was too narrow. So importantly, he and others didn't like that it was a statute and could be overridden by Parliament, and that it discriminated based on religion. After the proposal of the amendments that would become the Bill of Rights, Samuel Nasson of Massachusetts wrote of the Second Amendment that there, quote, would be no dispute between the people and the rulers in that may be secured the right to keep arms for common and extraordinary occasions, such as to secure ourselves against the wild beast, wild animals, and also to amuse us by fowling and for our defense against a common enemy. St. George Tucker's 1803 American edition of Blackstone's Commentaries was the most influential and widely used law textbook of the early Republic. Tucker was a Virginia Court of Appeals justice, a federal district judge, and a law professor at William and Mary. Excuse me. Tucker's Blackstone contained notes and materials explaining how the English legal tradition had developed in America, generally toward greater liberty. So he first noted that the Second Amendment was, quote, without any qualification as to their condition or degree, as is the case in the British government, comparing the Second Amendment to the 1689 Bill of Rights here, which did have qualifications. Then, referencing Blackstone's thoughts on the game law's ulterior motives, he noted that, quote, whoever examines the forest and game laws in the British Code will readily perceive that the right of keeping arms is effectively taken away from the people of England. In a long appendix that was the first scholarly treatise on the American constitutional law, he wrote the following here. In England, the people have been disarmed, generally under the specious pretext of preserving the game, a never-failing lure to bring over the landed aristocracy to support any measure under that mask, though calculated for a very different purpose. His lecture notes were very similar. In England, the people have been disarmed under the specious pretext of preserving the game. By the alluring idea, the landed aristocracy have been brought to side with the court in a measure evidently calculated to check the effect of any ferment which the measures of government may produce in the minds of the people. The game laws are a consolation for the government, a rattle for the gentry, and a rack for the nation. That consolation word is a bit unclear in his notes. They were handwritten. Scholar David Hardy went to William and Mary to check them. William Rawle, author of the next major constitutional treatise, his 1825 A View of the Constitution of the United States, also agreed, and you can read that here. An arbitrary code for the preservation of game in that country has long disgraced them, and so on. He says it's for the purpose of the game laws is for the prevention of popular insurrections and resistance to government by disarming the people. Some 19th century court cases also speak to the matter. McConaughey versus Singleton, an 1818 case, and I'll have cites to this and most of the other quotes I mentioned on the last slide, said that, quote, the right to hunt on unenclosed and uncultivated lands has never been disputed. And it is well known, these are US cases now, it is well known that it has been universally exercised from the first settlement of the country up to the present time. Obedient as our ancestors were to the laws of the country, a civil war would have been the consequence of an attempt, even by the legislature, to enforce a restraint on this privilege. And also, same case, the right to hunt on unenclosed lands, I think, therefore, is clearly established. Then, interestingly, a theme that comes up a lot in the founding generation and around the Constitution, it says this. Large standing armies are, perhaps, widely considered as dangerous to our free institutions. The militia, therefore, necessarily constitutes the greatest security, our greatest security against aggression. Our forest is the great field in which in the pursuit of game, they, meaning the militia, learn the dexterous use and consequent certainty of firearms, and great and decided advantages of which have been seen and felt on too many occasions to be forgotten or to require a recurrence to. So notice how in all of this hunting is tied together with a healthy civic life and a defense against tyranny. Nunn versus State, an 1846 case, which referred to the federal Second Amendment of the U.S. Constitution, said, quote, originally referring to the right to hunt, originally belonging to our forefathers, was trampled underfoot by Charles I and his two wicked sons and successors, reestablished by the Revolution of 1688, conveyed to this land of liberty by the colonists, end quote. An 1888 case out of Michigan, the Nunn v. State was out of Georgia. Sterling versus Jackson, Michigan case of 1888. It was adjudicating a public trust doctrine case. A dissenting judge said, quote, "We can borrow no light in this discussion from the English game and forestry laws, which are not part of our common law and which are repugnant and hostile to the theory of our institutions." Okay. So we've talked about England, we've talked about colonial times, we've talked about the 19th century. So what, right? Is all of this an anachronism? Is all of this just old stuff that doesn't matter now? Well, no, in fact. Enter Patsone and Nakamura, cases from the 20th century. The game laws are back, this time in the context of hostility to legal aliens. Pennsylvania and Colorado had laws that made it unlawful for legal aliens to hunt and to possess, importantly, firearms for hunting firearms. So Patsone went up to the U.S. Supreme Court. Justice Oliver Wendell Holmes upheld the Patsone statute, upheld the Pennsylvania statute, which isn't surprising given his uber belief in majoritarianism. Holmes was this hyper positivist who would always go with what almost always go with what the legislature said. And his opinion was filled with implied hostility to aliens. It's not surprising that you see that in some of Holmes's other opinions, where he talks about 3 generations of imbeciles being enough and why it's okay to sterilize someone. Very much to its credit, our southern neighbors in Colorado here, the Supreme Court struck the statute in Nakamura and said it was unconstitutional under the Colorado Constitution. So fast forward to District of Columbia versus Heller. As probably most of you know, Heller said that the Second Amendment protects the militia use of arms, but whether it also protects the right to possess and use guns for non-military purposes like hunting and personal self-defense is the question presented by this case. And of course, it held in the affirmative. It said the Second Amendment is an individual right, which covers these things. It's not just a militia thing. Heller also said, quote, "Preserving the militia was not the only reason Americans valued the ancient right. Most undoubtedly thought it even more important for self-defense and hunting. All lower courts to address the issue have agreed that the Second Amendment right includes arms for hunting, and citations to those cases will be on the last slide here. So did the DC Circuit decision that was affirmed in Heller. Okay, so that's the federal Constitution, right? And all of the background that goes into it. What about state constitutions? So 23 or 24 states' constitutions include right to hunt provisions, depending on whether you count Alaska. And the materials for today, which will be links to which and sites to which will be on the last slide, contain the list. Vermont put the right to hunt into its 1777 Constitution, as we discussed, and it's kept it there since. All the other constitutional provisions were added in 1996 or later. They generally acknowledge the government's authority to regulate hunting and fishing for long-term conservation. So here are some provisions from states in our region here. Wyoming and Montana. Wyoming, Montana, and Utah, Idaho, and North Dakota is on the next slide. Refer to hunting as part of our heritage, right? So this very deep, they talk about these provisions in this very deep sense that it's part of what makes them, in this case, citizens of our states, right? Citizens of the states to which we belong. Wyoming's and Montana's also specifically state that they don't alter existing trespass laws or other property rights. Idaho's, like several others, protects the right to hunt via traditional methods. So, for example, no dynamite fishing is allowed, right? This wouldn't protect dynamite fishing. Idaho's and North Dakota's also protect fishing and trapping, right? These are all typical features. These show up in the hunting and fishing provisions of many states. Other interesting provisions not represented here are, for example, Arkansas's, which states that harvesting game is the preferred method of managing non-threatened species. And Alaska's, and we'll come back to that point, the point of species management and how do we do that when they encroach on human human habitation and that sort of thing. Alaska's is another interesting one. It doesn't speak of a right to hunt, but it says that wildlife belongs to the people for their use. So interpret that as you will. Maybe that speaks somewhat to the Alaska's indigenous population. By contrast, South Dakota, New Mexico, and Nevada don't have provisions. They don't have these kinds of provisions. So you might wonder how all of these came about. How did we get this? So after all, hunting is a regulated sport that promotes conservation. Few people, except maybe law professors, think of hunting as an activity that supports a thriving egalitarian republic like the founders did, right? Well, one might view two new political forces as replacing the crown, as we talked about at the very beginning, in trying to repress hunting by ordinary citizens. The first are animal rights activists on the extreme. So obviously not all animal rights activists, but only the extremists. There are groups out there that abhor hunting in and of itself and often view those who would hunt as reprobates unworthy of civic inclusion. There are even scattered stories of what you might call terrorism surrounding this. Eco-terrorism is a phrase that's kind of out there sometimes. The second is increasing urban and suburban sprawl into hunting areas and calls from that sprawl to restrict nearby firearm hunting. That led to deer overpopulations, which some localities try to remedy with bow hunting. And that bow hunting itself has been challenged by some animal rights groups. And strange things, and think back to the provision I mentioned earlier, like deer contraception. Some groups prefer, say that deer contraception should be used instead of hunting. Ironically, deer contraception is developed using pig ovaries. And so the response to this in many states has been the official recognition of the right to hunt. In Virginia, it was actually by referendum. So how do these play out? How do these provisions play out in the states? So there's very little case law involving these provisions. The few cases that are easily found upheld challenges to bag limits and closing areas for conservation reasons. An interesting case from West Virginia upheld a ban on hunting on private land on Sundays. It was actually an ACLU case where the state chapter's executive director said, quote, "Our state motto may say mountaineers are always free, but in Ritchie County, they're only free Monday through Saturday," end quote. One case from Virginia upheld a zoning denial to install a sporting clays facility on a hunting preserve. It construed hunting quite narrowly to include only, quote, "the pursuit of game," declining to include ancillary activities like training and more humane substitutes. So that's interesting. You'll generally in the broader arms bearing context, you'll see the incidence of the right to bear arms protected. So the right to practice at a range, for example, is protected in old cases from the early 19th or throughout the 19th century, and for more modern cases in the 20th century, more modern post-Heller Second Amendment cases protect the incidence of hunting, the incidence of the right to bear arms, not this Virginia case. One last case I've got here, there's an interesting set of cases in Montana relating to wolf hunting. So it started with a 2020 case, which was the first to invoke the state's right to hunt provision, arguing that expanded wolf quotas were needed because an overabundance of wolves was damaging elk and other populations. In response to that, the legislature enacted new wolf hunting laws, and in 2021, the Montana Fish and Wildlife Commission established an expanded wolf hunt, giving the plaintiffs in that case what they wanted. After that, wolf hunting seasons were scheduled, and they're still out there now. If you look, you can find out when they are and get a wolf hunting license and so on. But almost immediately after certainly after the 2021 with the expanded wolf hunt, lawsuits began to stop the wolf hunt by conservation groups, and those there are a few of them out there, and they're still ongoing today. So we'll see exactly how that plays out. It'll be interesting because there are state and federal grounds on which potentially they can sue here, and so we'll see exactly how that'll play out and where that'll end up. Some may not implicate the Montana Constitution, some may be in conflict with it, and so on. So finally, to close, and then we can have a discussion and do some questions. For those interested in reading more, or those who from other states who need written materials for CLE, here are some links to them and some further reading and citations to some of the sources mentioned, to most of the sources mentioned today. This file here, if you go to that website, firearmsregulation.org, and go to the students material tab. This is the website for the casebook on which I'm a co-author. There's a file there that has all of the state constitutional right to hunt and right to fish provisions, if that interests you, and you can find them, see what all their different provisions are. If you're interested in the English history, one great source that summarizes this very well is the free online chapter 22 of the casebook, and it talks about basically the evolution of arms rights from England, from really back to medieval England, coming through just up to the colonies. Blackstone, of course, is a great source for this. Individual page numbers for Blackstone are listed in the chapter here. Robert Held was the historian I mentioned. That's his book there. William Cobbett, another famous American history book there. David Ramsey, 1789. It's about as a coincident with the Second Amendment as you can get. Some stories, some news stories, some newspaper articles from the time when the Bill of Rights was being proposed, and then the Bill of Rights and the new Constitution was being debated. Here are citations to the three cases I mentioned, explicitly talking about the right to hunt. Here's Parker v. District of Columbia, Heller's predecessor at the DC Circuit, which was affirmed by Heller. And these are the post-Heller cases that I mentioned that talk about the right to hunt as the things that Heller says are protected. And so with that, I'll thank you for your time. We've got about 13 minutes here in which we can take questions and have a discussion about the topic.
Professor?
Go ahead, sir.
Yeah, my name is Lee Mickus. I'm a lawyer in Colorado. I'd be interested in your thoughts and comments on this issue as it intersects with the fairly famous corner crossing case that the Wyoming Federal District Court recently ruled upon, and that's now pending in the 10th Circuit.
Yeah. So a couple of things there, just to give a little background. And actually, so in Wyoming, the law was, and I don't know actually what this court ruled, so I'm glad you told us about it. In Wyoming, the rule is that it takes kind of the notion that property rights extend from the property line up through to infinity rather seriously. So if you have two pieces of property coming together in a square, and you're allowed to be on this one and on that one, but not on these two. You're not allowed to step over. So what did the district court say? I didn't actually know. I hadn't heard what the results of that case were.
Yeah, the district court ruled in favor of the hunters and found that stepping from public land to public land across a corner with shared private land was not a trespass.
Interesting, interesting. So lots of hunters and conservation types were hoping that would be the case. So we know that the Wyoming Constitution here under says that it doesn't create a right to trespass on private property. So presumably the Wyoming provision was not intended to overcome that law, or not intended to, to override that presumably common law rule in Wyoming that you couldn't cross a corner like that. Now, what was the grounds on which the federal district court ruled? Do you know?
It can be characterized in a number of different ways, but it's essentially that the passing through the air was so de minimis, and that to enforce the trespass law of Wyoming would in essence violate federal statute that allows for full access to the BLM and other federal lands that otherwise would be inaccessible.
Interesting. Very, and so that I'm so glad you brought this particular case up, right? Because it gets to the point we talked about at the very end. What these state constitutional provisions might, that Wyoming common law rule, presumably, I think it's a fair read to say this constitutional provision, Wyoming Constitution, Article 1, Section 39 here, does not abrogate that state common law rule, and wasn't intended to. But that's just in Wyoming, right? Federal law is, reigns supreme over state law, I suppose. It doesn't sound like it was a constitutional question in any way, but federal law does trump, right? Federal law does trump state law. And so here's a federal court saying, too bad this is what your common law is, or this is what, I don't know if it even considered this Wyoming constitutional provision. Presumably the defendant, the defendants here would have cited to that law, would have cited to this constitutional provision. But the federal court said, look, that's a different domain. Federal law says there's a right to go from one piece of federal property to the other. It's de minimis. And so here's our decision, right? So it's a perfect example of that interesting interplay between the national law, right, or general law, as they like to call it. I suppose national law is the right word. In the 19th century and earlier, and the states trying to do something pretty important, right? This is our heritage and so on, but still having this sense of that property rights trump one's right to engage in this activity. So very interesting. I'll be very interesting to see where it goes in the 10th Circuit. And I'm now that you've told me about it, I will track that case. So thank you very much for telling all of us about it, and we appreciate it.
Absolutely.
Let's see. There's a question here. I'm just reading from the chat here. In fact, I'll move the chat here. Some organizations are starting to use ballot initiative referendum processes to ban the hunting of certain species, often over the objections of state wildlife managers. Recognizing that there are legal differences with initiatives or referendums that seek bans via statutes versus constitutional amendment, excuse me, could you speak to whether state constitutional amendments protecting the rights to hunt might serve as a potential defense to ballot initiatives aimed at ending hunting specific species? Would your analysis be different if the initiative sought to end all hunting? Great question. Really great question. So I think I'll kind of get a little meta and a little bit ivory tower for a moment here and say that fundamentally constitutional rights, whether that's at the federal level or the state level, right? And then if they conflict, then presumably the federal constitution trumps and so on. But even at the state level, constitutional rights are supposed to be the reason they exist is to take certain policy choices off the table, right? Constitutions are supposed to be anti-majoritarian documents that say that some things are just out of the realm of governmental lawmaking, whether that's through legislative means, whether that's through initiatives or referendums, even whether that's through judicial opinions or administrative rule, right? So I think at the meta level, the answer is yes. Now, of course, the devil's always in the details. In any given case, a court would have to take into account things like the North American model, right, where game is thought to be is thought to belong to the people as a whole, to the population as a whole, right? And so, if there's a good conservation reason to ban the hunting of a certain type of animal, for example, I think, generally speaking, a court would uphold the ban, whether it's by referendum or not. But, mentioning specifically referendum, and I don't want to read into the question there, but there's this implication that a referendum-based ban might have less to do with conservation or specific needs or a sort of a justifiable need, and potentially have something to do more with emotion or something like that, right? Maybe it reminds me of the ban on eating horses or selling horse meat that went into effect some years ago. In Europe, it's not all that difficult to get horse meat, right? And so there was the sense, at least according to some, that this was somewhat based on emotion and trying to impose a view about what animals are proper to hunt and not. In that situation, that's the kind of situation, I think, where a right to hunt provision, a state constitutional right to hunt, would really come into the picture, right? If it's not for valid conservation reasons, I think more broadly is when the question of what the state constitution says about it really becomes salient. And then just the second part of the question, I think, kind of flows from this. Would the analysis be different if the initiative sought to end all hunting? I think yes. I think from a different direction, there may be a sense out there, and we talked about an example of this, again, going back to England, right? The precursor of all this. That, remember, the historian said, it's one thing to tell a person you can only hunt a certain way or with a certain weapon. It's another thing to tell a person that you can't put food on the table, right, via hunting, especially if that's the only way you can do it, like in that area of Mississippi that I mentioned, where many people at the time, at the time that we talked about, relied on that to get fresh lean meat on the table. So I think if a referendum banned all hunting, it would certainly be a much stronger case under a state constitutional provision. Someone put into the chat, thank you very much for that. The corner crossing case is Iron Bar Holdings versus Cape. So if anyone wants that, Iron Bar Holdings versus Cape, if you'd like to look that up. Any other questions? Okay, so
I have a question.
Yes, go ahead, please.
Yeah, reading in the past, reading the Federalist Papers, Hamilton J. and Madison, and I could be wrong on this, but I don't recall when they did discuss the Second Amendment talking about a right to hunt. Did they?
I don't recall that either. I don't recall that either. If they did speak of it in the Federalist Papers, it would only have been in passing. I think you're correct about that. Most of the debates in the Federalist Papers over arms rights in general,
Yeah.
you can think of the right to hunt as being a subcategory, part of the right to hunt as being a subcategory of the right to arms, right? One part of it. Most of it was around preservation of the militias and the popular militia in particular, right? This notion that the militia, as thought of at the time and referred to in the Constitution, comprises the population as a whole, all of the capable population as a whole. And obviously, it was more restricted back then than it is now, by the way. At the time, the militia was only, free white males, 16 to 45 or 16 to 60, depending on where you look. The current statutory definition of the militia is much broader than that. It includes, for example, obviously all races. It includes women in the National Guard and so on. And some talk of self-defense. If there was a hunting, and the Federalist Papers were all about kind of addressing the publicly stated worries about the Constitution, right, and fear of a standing army and so on. And so that's generally what they answered. So if they do mention them, and they may, but it would only have been in passing.
Thank you. Thank you.
Thank you. Okay, with that, I'll thank everyone for coming. Thank you very much. Someone asked about the slides. Feel free to email me. I'm happy to send you the slides, but I will say that this recording of this CLE will also be on the Firearms Research Center's website. That website is firearmsresearchcenter.org. And then click on the resource tab and go to video library, or just firearmsresearchcenter.org/video-library. I'll also put in a quick plug if this CLE interested you, and if CLEs related to firearms interest you. If you go to firearmsresearchcenter.org/events, we have 2 upcoming events. We've got our fall symposium on the National Firearms Act on October 18th. It's a full day event going from about 8:30 to 3:30 or thereabouts. And there'll be several hours of CLE credit available there. You can come in person at the College of Law in Laramie, and we're working on getting a Zoom link, Zoom webinar link up for that as well. That should be up today or in the next couple of days. The evening before, we've got a joint event with the law school's J. Reuben Clark Society and Federalist Society chapters. We will have, it'll be a fireside chat format. I'll be asking questions from Judge Lawrence Van Dyke of the Ninth Circuit and Judge Thomas B. Griffith, formerly of the DC Circuit. Just asking them about their judging and their judging style and their various views on this kind of thing. If you'd like to join for either of those, that one is also in person, and we also hope to get a video link up for that. The fireside chat has already been approved for CLE, and we're just, we should have the approval for the CLE for the National Firearms event. National Firearms Act event in just a couple of days here. And I would encourage you to keep an eye on our website, especially the forum, where we announce lots of things, and the events page, because we hope to do more events, both for CLE and not. Some of our videos are not for CLE, some are. But if the topic interests you, I encourage you to keep an eye on it and tune in whenever something interests you. So with that, thank you very much. Thank you for coming. And please join us next time. Have a great day.